go. You're recording. Please be sure to let everyone know that they're being recorded. Dismiss. Okay. Morning, guys. Okay, so today we're going to be talking about infringement, and that is pages 273 to 282 of Dean and Dyer. It doesn't look like a lot, but there are some slippery concepts in here. This is part of the this is typical IP and typical patents in the sense that it looks simple on the face of it, but then when you start trying to wrestle with the concepts, you realize that intellectually speaking they can be a bit slippery. So you kind of have to get your head around them. And as always with these things, if you start with the basics and build up towards them, and do it on a solve from first principles basis, always bearing in mind the philosophy behind it, then these things become manageable in the fullness of time. So we're just gonna start at the beginning and work our way through it, and you'll see it's quite sort of interesting. Infringement is of course the sharp end of patent law, because this is ultimately why you get yourself a patent, why you pay all of that money to get patent protection. It's the right to exclude others from making or using your invention, and so infringement provides for you to actually get stuck in there and stop third parties from unlawfully using your invention. So it's the most powerful aspect of patent law. It's the sharp end of the blade, and it's quite sort of tricky, and it's adversarial, so you have to be on top of your game the whole time and figure out how it works and have a good understanding of the act and the case law and the sort of philosophy behind it. So on that basis, the first question is, well, who can sue for infringement? And obviously the answer is, well, the owner of the patent, right? The proprietor, the patentee. But that also begs the question, well, who else? What about a licensee? What about an exclusive licensee? And this is all covered by section 65 of the Act. So interestingly, if you've got Dean and Dyer open in front of you, this is a very good example how Dean and Dyer is a very, very good book, but that doesn't mean to say it doesn't have mistakes in it. And the first mistake is under footnote 176, where you can see there it says section 61(1) of the Patents Act. It's not correct. It's section 65(1) of the Patents Act. So please just annotate your notes to say that that is the correct reference, right? So section 65, what does section 65 say? Section 65 is chapter 11 of the Patents Act. Infringement. 65, proceedings for infringement. 65(1), subject to the provisions of section 53(3), proceedings for infringement of a patent may be instituted by the patentee. Okay, cool beans. What about a licensee? Okay, a patentee must give a notice to every licensee who's recorded on the register. So if you're not recorded, then you don't have the right to be given notice. And then if you recorded on the register and you get given notice in terms of section 65(5), then as a licensee you can intervene as co-plaintiff, which would be very much in your interest, because you're the one who's paying royalties under the patent, and now here's this guy sort of doing what you're paying for with impunity. So you want to be part of that deal, so you want to get him as well, so you want to be in there. So section 65(5) says the plaintiff in any such proceeding shall, before he institutes the proceedings, give notice thereof to every licensee under the patent in question whose name is recorded on the register, and any such licensee shall be entitled to intervene as co-plaintiff. Whenever I read the Patents Act, I always cringe, because it's so politically incorrect. The plaintiff in any such proceedings shall, before he institutes the proceedings. Pronouns are just like so last century. But anyway, how it goes. And the application you have to give to that. So, he includes, she includes, them includes, all the pronouns. So, but, every now and then you see, sort of things like that, which just give you pause for thought to see how far we've come as a society. I always regarded it quite interesting. When was this drafted? 1977. So sort of 45 years ago. Yeah, different age, man, different age. Anyway. Okay, locus standi. Patent has the locus standi to institute an action for infringement. What about joint owners? Okay, because Joint ownership is not something that we've really spoken about in the past, but it's a tricky one. And I want to just take a moment to speak about it now, because it's something you have to be wary of. Joint ownership of granted patents is provided for in Section 49 of the Act, which I'm just getting up now, 51. Here we go. Ugh. Okay, joint ownership and patents, right? If you ever get into practice and you ever are advising, strategically speaking, on patents or anything like that, just rule number one, avoid joint ownership of patents. They're just a nightmare, okay? And if you do have joint ownership of patents, then you must have a joint ownership agreement, because otherwise the provisions of Section 49 are the ones which apply, and they are not cool, okay? Joint ownership in patents. 49.1. Where a patent is granted to two or more persons jointly, each of the joint patentees shall, in the absence of an agreement to the contrary, i.e., guys, put one together, please, because otherwise this is what is going to apply. In the absence of an agreement to the contrary, the joint patentee shall be entitled to an equal, undivided share in the patent, right? So this whole amorphous patent is just down the middle. So you can't say you've got that bit and I've got this bit. It's equal, undivided. Okay. A joint patentee shall, in the absence of an agreement to the contrary and in the absence of consent of the other joint patentee or patentees, not be entitled to make, use, exercise, offer to dispose of, or import the patented invention, i.e., all of the acts under Section 45, which I'll get to in a moment. Grant a license or assign the whole or any part of his interest in the patent, or to take any steps or institute any proceedings relating to the patent, okay, provided that he may pay any renewal fee that is payable without recourse to the other patentees. So you really can't do anything, okay? You can't make the patent itself. You can't sell your bit of the patent. You can't license it. You're just stuck there, and unless you've got an agreement with the other patentees. Having said that, we then go down to 49.4, which does say that any joint patentee may institute proceedings for infringement and shall give notice thereof to every other joint patentee, and any such other patentee may intervene as co-plaintiff and recover any damages in respect of any damage he may have suffered as a result of the infringement. Okay, so that says, despite all the things you can't do, you can pay the renewal fee and you can institute proceedings for infringement, okay, including against your joint patentees, who are not allowed to make, use, exercise, dispose of, etc., in terms of Section 249.2a, right, which is what we just spoken about. So that's like a little dog leg there. You've really got to watch out about joint ownership in patents. It's a dodgy question. It's a tricky question. So it's something always to be aware of. Okay, so if you're a joint ownership, you can institute proceedings if you give others notice. Otherwise, your hands are tied. Okay. In order to determine whether there has been an act of infringement of a particular patent, there's three things you've got to do. You've got to decide whether the act, the alleged infringing act, is of such a nature that it could constitute infringement of the patent, or whether the act is excusable. So that means you've got to read it against Section 45, which I'll get into in a moment. You've then got to construe the ambit of the claims. Okay. Now, this is construe is a fantastic word. Okay, and it's used a lot in the Patent Office. If you look up the meaning of the word construe, which I will do now. Construe meaning. The Google definition is to interpret a word or an action in a particular way. For example, his words could hardly be construed as an apology. And the other one is to understand the meaning, especially of other people's actions and statements. In particular, any changes to the plan would be construed as indecision. So it is derived from the word construct. Oh, sorry. Hey, Danielle, hands up. Yeah.
Prof, I believe we are in chapter 5, page 273, but I'm not following where you are reading.
Chapter 5.62.2, construe the claims of the patent in order to determine whether the alleged infringement falls within the scope of any of the claims.
It's 5 point.
5.6.2.2.
5.6 point. Let's see, because I'm not following at all, and I need to.
Remember, I don't read slavishly from the book. The book is just it's there to provide sort of general guidance. If there's something interesting, then we will always take an excursion.
Okay, but you are reading at 5.6.6 construction of the claims.
No, I'm reading at 5.6.2 determination of infringement, page 273.
Okay, thank you, Prof.
Okay. All right, so we're talking about the meaning of the word construe, which means to understand the meaning, and it is derived from the word construct, which means to build or sort of to deconstruct or sort of just understand how the parts fit together. So when we talk about construing the claims, it's meaning figuring out what they mean. Danae, your hand is still up, yeah?
No, I've lowered it up.
There we go. Hey, Sally, did you sleep in?
Morning, Prof. Sorry for being late. My laptop just crashed. I've been struggling to connect.
No worries. This has been recorded, so you can pick up the first few minutes when I post it onto Blackboard in due course. So we're on page 273 of Dean and Dyer, chapter 5.6.2, determination of infringement. And we've just decided that you have to look at the act, you have to construe the ambit of the claims, and then you have to establish whether the defendant has a valid defense. So what we're basically doing is talking about an infringement in the sense of you have to test what has been done against the ambit of the claim. And if what has been done falls within the ambit of the claim and he doesn't have a valid defense, then that's infringement. Okay, so that's what we're talking about today. So now we get to the heart of the act, which is section 45. Okay, so section 45 is by far my favorite section in the act, because this is really what it's all about. Okay. And so I'm just bringing up section 45 now because it's the effect of a patent. Okay, and it reads, the effect of a patent shall be to grant to the patentee in the Republic, subject to the provisions of this Act, for the duration of the patent, the right to exclude other persons from making, using, exercising, disposing of, or offering to dispose of, or importing the invention, so that he or she shall have and enjoy the whole profit and advantage accruing by reason of the invention. Okay, that's it. That is the Patents Act in one section, in one sentence. Okay, so that he or she shall have and enjoy the whole profit and advantage accruing by reason of the invention. That's it in a thing. Now, you will recall that you guys have your I'm sure you're working very hard on your assignments, which deals with whether non-natural persons can be an inventor. And so I would like to draw your attention to some wording in section 45, which says, so that he or she shall have and enjoy the whole profit and advantage accruing by reason of the invention. I think that you can infer a great deal from that wording. He or she. They don't say they don't say it. They say he or she, which are both persons, right? They're not legal entities. They're not, they are persons, natural persons. And I think that is a huge part of the Patents Act. And it's a very important aspect which I expect to be explored in your assignments. This section 45, it's a big giveaway about the intention of the act and what the act is all about on a core philosophical level. So yeah, I want you to pay attention to that in your assignments, that word he or she. Okay, but for today, we're going to focus on the acts which the patent gives the patentee the right to exclude other persons from doing. And in terms of section 45, they are making, using, exercising, disposing of, offering to dispose of, and importing the invention. Okay, I think there's 6 of them. Yeah, 6 of them. Okay, and you need to know each of those acts, right? So the UK Act has a very similar wording, but the UK Act is slightly different. They say make, use, dispose of, offer to dispose of, import, and keep. Okay. Also 6 acts, but differs by 2. The UK Act has got keep. We don't have keep. And we have exercise instead of keep. Okay. So I always remember the UK excluded acts because I use a little acronym. I use the first letter from each of the excluded acts, which in the UK is M for make, U for use, D for dispose of, O for offer to dispose of, I for import, and K for keep. So my acronym is MUDOIK, MUDOIK. Okay. In South Africa, it's not so easy because in South Africa, you've got make, use, exercise, dispose of, offer to dispose of, and import. Okay, also 6 acts, but it's MUDOI, which is not so cool. So what I tend to do is for sort of mental shorthand is I always use MUDOIK, make, use, dispose of, offer, dispose of, import, and keep. And then I just make a little mental note to say South Africa doesn't talk about keep and instead talks about exercise. And I don't think, I've always battled with the difference between exercise and use. What you know, what's the difference? You know, I think it's semantics. So it is what it is. And also I think to not say keep is a bit of an oversight because, you know, keep is an important act of infringement. You could have warehouses full of these things that you're not doing anything with, you know, you're just keeping. And that's technically, you'd really have to do some verbal gymnastics to get that act of holding a warehouse full of infringing articles to fall within one of the South African excluded acts. So it's just an interesting thing. I think I'm lucky because of my exposure to the UK Act that I have this sort of approach. But I think, you know, in South Africa, you'd battle to get away with keep, but I just think it's a bit of short-sightedness that they didn't include the word keep in the 78 Act as a excluded act. But anyway, we have what we have. We have make, we have use, we have exercise, we have dispose of, we have offer to dispose of, and we have import. So we're going to look at all 6 of those acts in a little bit more detail now. So now we're down to 5.6.3.1, making, okay? And really, the act there is the case is Donna Corporation versus Robrake, and you know you've got that you've got an ordinary dictionary definition to form by putting parts together or combining substances to alter something so that it forms something else. Okay, so yeah, that you can make something, and even if you don't sell it, that's still an act of infringement. You can repair if you've bought it from the patentee, but you cannot, under the guise of repair, make something which is essentially new. Okay, so making, I mean, it's pretty simple on the face of it. You make something. It wasn't there before you began. You start tinkering, mixing, screwing things together, whatever, and then you arrive at something that wasn't there before you started. You've made something, okay? And if that something falls within a claim, which is valid and in force, and you don't have a defense, that's an infringement. Okay, so that's making. Second one, using. According to the Oxford Online Dictionary, the act of using means to put into practice, to carry on action or effect. Okay, so you use an industrial process, etc., etc. So you should just read there, you know, about innocent possession of a patented article may not amount to use, but possession of a patented article with the intention of using it for trade purposes does amount to use. And there we have where keep as an act would possibly fall within the South African wording. Okay, possession of a patented article with the intention of using it for trade purposes. But now all of a sudden you need mens rea, so intention. Don't really feel like that's a bit of a tricky argument. It would be so much easier if they just included the word keep. Two very important aspects about use, and the first is that experimental use of an invention amounts to an infringement, even if the experimenter uses the invention, just on a non-commercial scale. This is not cool, okay? So the effect of this is quite extensive, because say you say, oh, okay, here's a method of extracting gold from rock, and there's the patent, and now somebody, a competitor of yours comes along and wants to actually test it, maybe improve it, see that if it works, etc., etc. Just for him to build like a setup and use it experimentally, that's infringement, And I'm not sure that really is allied with the intention of the act. I think if you're going to have a patent, if you're going to have the right to exclude others, you need to, I think your patent needs to be stress tested. It needs to be shown that it can work or it doesn't work. I mean, after all, if it doesn't work, it's a ground for revocation, right? So you need to be able to test it. You need to be able to experiment with it. And a slavish closed reading of Section 45 experimental use, that's infringement. So I think that's a bit of an oversight. I think they're looking at it in terms of the new amendments which they're looking at. But for the time being, experimental use, technically infringement, which is not popular in the industry, I can tell you. You need to be able to stress test inventions, okay? And the other one, which is very important, is Section 69A of the Act. Now, when you have a little A afterwards, you can see it's been included as an afterthought, or it's been included because things have moved on since 1978, which they have. And so what Section 69A is all about, it's the so-called BOLAR provision, which is, it's named after the case in America. And basically what it is this was an emerging trend internationally, and the South Africans thought, better include it in the Act. So what it does is, Section 69A says it shall not be an act of infringement of a patent to make, use, exercise, of the patented invention on a non-commercial scale, and solely for the purposes reasonably related to the obtaining, development, and submission of information required under any law that regulates the manufacture, production, distribution, use, or sale of any product. Okay. And it shall not be permitted to possess, the patent and invention made for purposes other than for obtaining, development, or submission of information as contemplated in that subsection. So what is this talking about? It's talking about regulatory approval for pharmaceuticals, veterinary products, agrochemicals, and things like that. So, obviously, before you can sell a medicine or anything like that in this country, you need Medicines Control Council permission, and you need to prove that it works and how poisonous it is. Interestingly, it's called the KD50 number, which is how much do you have to give to a population of rats before half of the rats die? Kill death 50%. And so, all of that kind of data. What are the blood levels after 1 minute of administration, 5 minutes, 10 minutes? What's its half-life in the bloodstream? What are its side effects? All this kind of data, right? So when you are the first person to bring a drug to market, when you've got the core patent, you've got to do all of that data and you submit it as a dossier. And it takes years and years and years to get that, right? And that's why I think we've spoken about it before. Patented medicines are so expensive because you have to get all this regulatory approval in South Africa, for example, and the US and Europe and China. Wherever you want to sell it, you have to satisfy that country's regulation authorities that you've got this, you've got all this data, and you put together that dossier. They look at it, and then finally they say, okay, cool, you can sell it. But by now, it's taken 15 years to get to that point. So you've only got 5 years of the 20-year patent duration left to make up all the money that it costs to develop and test the drug. So That's why they're so expensive, because you've got 5 years to make up this costing. All the generics know that, you know, your patent expires on the 1st of March 2023, right? And they are waiting in the wings just to come in and sell, okay? But now they need the same data. They need regulatory approval as well. And so what this basically means is that, and they can't really trade on your coattails. They basically have to put those data packs together and submit them to the MCC themselves. And so what section 69A says, that you can do that while the patent is still pending. You can use it to get safety data, bioavailability, half-life, KD50 numbers, whatever. You can get all of that together and it won't be an infringement, okay? If it's only used and only solely used to put together your data pack, okay? Your dossier for application to regulate the manufacture, production, distribution, okay? So you can do all of that and it's not an infringement. It's called the BOLA provision. But what you can't do is once you've got your generic permission, okay, so you're good to go. You've now submitted all your safety data. The MCC have said, yeah, it's exactly like the original. That's fine. When the original comes off patent on the 1st of March 2023, you can make and sell. What you can't do under section 69A is then start making and packing your warehouses full, so that on the day you just ship product. You can't do that, okay? You can't stockpile under 69A. You can just get your regulatory affairs in order. Then from the 1st of March, then you can start making. Then you can start distributing, etc., etc. But you can't make for commercial purposes pending the expiry of the patent. That's a very important aspect of the BOLA provisions under 69A. So, okay. And of course, the same is true for veterinary products. They require very similar sort of regulatory approval, and also pesticides and other organic products like that, fertilizers. There are, you know, regulatory bodies in South Africa that you have to have permission from before you can make and sell here. And so 69A applies equally to fertilizers and veterinary products and agricultural pesticides and things like that. So, you know, it's quite broad reaching. So that's why it says use is limited by the so-called BOLA provision in section 69A. This section makes provision for use of an invention in order to obtain regulatory approval, and it's discussed below, but we've already discussed it, so there we have it. Okay. Interestingly, I do a lot of work on BOLA provisions, right? So I act for generic companies who are targeting, you know, pharmaceuticals which are under patent in South Africa. So my instructions from these generic companies are, John, here is the European patent for tremoxylene or whatever, which we believe comes off patent in South Africa next year. We want to launch shortly thereafter, but we also need to see what the patent situation is in South Africa. You know, have a look at this and tell me about the corresponding South African situation. Okay, so I take that European patent that the generic gives me, which covers the original patent, the original pharmaceutical, and then I will investigate whether there are any corresponding South African patents, and there might be one, there might be 2 or 3. And then what I'll do is I'll look, are they still in force? Have they been granted? Have all the renewal fees been paid? And then I'll get copies of those patents from the South African Patent Office, and I'll look at the claims, and I'll say, you know, are the claims, do they look valid? And most importantly, have they been amended to reflect amendments that were made on corresponding overseas patents, right? And why is that? Because remember last week we were talking about the conduct of the patentee, and if he hasn't made corresponding amendments in South Africa, he's in a problem area. You know, under section 69, if he's got one invalid patent, he might not be granted relief, he might not be granted damages, etc., etc. Conduct of the patentee, remember that's a very important phrase. So we'll look at that to see whether the major patent holder has done all of those things. And then we'll wait. If he hasn't done those things, we might make an application now to revoke, to say, listen, this guy's been pulling the ring for 18 years, you know. He knew very well that this claim is not valid because it was rejected in Europe, but he held it in South Africa all this time he can't be allowed to amend it now. You know, the conduct of the patentee has been atrocious under the circumstances. So we might do that, or we might say, okay, he's done his homework, it's valid in force. But 1st of March 2023, it's good to go. So let's go. So we're waiting, and we've got all of these things in the wings about whether it's worth it to try and go for it, to have it revoked, whether it's better. We think it's valid, so we'll just hunker down and wait for it to go off patent. And then, of course, the other thing, which is very important, is you've got to look and see if they've managed to sort of evergreen their original patent by saying, okay, the first patent said compound X, and if you use compound X, then that's excluded, and compound X comes to an end next year, 2023. So you can use compound X, but halfway through the life of the patent, they figured out that actually compound X works so much better if you co-administer it with compound Y. So what they're making and selling now is actually a combination of X and Y. And that's what you want to sell. You want to sell X and Y, because X and Y in combination works so much better than just X alone. So now you've got to sit and think, the first patent for X by itself expires next year, but nobody wants to do that anyway because it doesn't work as well. What you really want to do is you want to be able to sell X and Y together in combination. But that patent only expires in 2033. So what are we going to do about that? I can tell you we're going to do nothing about that because I retire in 2033. So that's somebody else's problem. But, that's the kind of thing that you have to worry about is, have they improved it along the way? Is the current formulation, which is being made and sold in South Africa, which is very popular in South Africa, is it in fact maybe the subject of a subsequent patent, which expires many years after the main patent, because it's just so much better, the improvement that they spoke about. And so that's like quite an important part of doing this, that things are working. Okay, again, I digress. I apologize. Okay, I think we whipped use to death. Okay, so making, using, fine. Now we come to exercising, the uniquely South African act, exercising. And I'll just read the book because really, I don't really know what to say. The act of exercising an invention means to put into operation, to employ, apply, make use of. Well, I mean, that sounds a lot like using, doesn't it? Okay. This act of infringement is of particular application to a process or a method which is normally exercised, that is to say, carried out as against a machine or an article or composition of matter which is generally used. Okay, look, I mean, really, I don't think much turns on this. I'm certainly not going to dwell on it. So you just appreciate that exercise. Do you exercise a process or do you use a process? Do you exercise a method or do you use a method? I think you use a method, because claims are drafted to methods of use. So, come on, guys. It's really, it's just odd. Exercise. Okay. Dispose of. Dispose of is a cool word because when you the ordinary dictionary meaning of dispose of is almost to disposal, throw it away, right? I don't want it. But actually, in the legal sense, dispose of is a catch-all phrase that means that I have it and then I don't have it. So somebody else has taken it from me, and I can have given it away. I can have sold it. I can have swapped it. I can have licensed it. Anything to get it from my possession to your disposition. So disposal is not limited to throwing away. Disposal of is literally meaning I had it and now you have it. Okay. So it means to bestow, make over, to deal out, distribute. And it's much broader in meaning than selling and much broader in meaning than throwing away. It encompasses acts such as giving away, loss of physical possession, and even destruction. So disposal is, when you dispose of something, it's your prerogative what you do with it. You give it away, you sell it, you destroy it, you throw it away, whatever, you bury it, throw it in the sea. It's all disposing, okay? And then offering to dispose of is simply advertisement. So if it's in your possession initially and you place an advert to say, do you want to buy it from me, or $5.99 for this thing and I'll send it to you, that's offering to dispose of, right? So even if you actually never dispose of it, just the mere act of putting it up for advertisement could possibly be an infringing act. And yeah, So I think that is the English case of No Fume Limited versus Frank Pitchford and Co. So you should just have a quick look at that one, about offering to dispose. And then the interesting thing about importing is that, you know, you've got a kind of bonded warehouses that you find at ports of import or ports of entry into the country are like a little bit weird to me. So it's like it's in South Africa, but a bonded warehouse means it's never entered South Africa because it's on its way to Botswana or whatever. And then it'll be hauled across South Africa and enter Botswana, and only then it enters South Africa. So it's almost like it never enters South Africa. So, so in its broad sense, importing means to bring in from an outside source or to bring in from abroad. But you've got to distinguish between goods in transit and imported goods. Goods in transit are bonded and are not destined for the South African market. So if patented articles are on transit via South Africa to another country, for example, Botswana, they land in Durban and they weren't washed away by the floods, then they put on a truck and trucked up to Botswana. To the extent they're technically in South Africa, they're not in South Africa. They're bonded, they're in transit. And so that wouldn't be an act of infringement, okay? Because the goods are not intended for the South African market. So those are the 6 acts: make, use, exercise, dispose of, offer to dispose of, and import, okay? And then on importing, you've got to make the difference between bonded and non-bonded or in transit, destined for another country, which is to say not destined for the South African market. So, you know, pretty easy on the face of it. And then a keep, of course, is part of using, because it's in your possession. Okay, so those are the acts. So you can't infringe a patent unless you do one of those 6 things, okay? And then the next thing you've got to, the next point you move on to is now you construe the claims to see whether that act fell within the area of the claim. But before we get onto that, I want to talk about presumptions in related to new substances, which is section 67 of the Act, which is a little bit tricky. This is what I want you to kind of get your head around. And this is another example of a mistake in Dean and Dyer. And we'll discuss that in a moment, because it's actually incorrect, the last sentence there. Okay, so say you have a patent or a process of making a new article, a new product, say a particular type of marble, all right? And it's very cool because, you know, this marble has got like you can see the galaxy inside of it, you know, when you look at it. There's no marble like this out there. It's unique, okay? But for whatever reason, you didn't, in your patent, you just claimed a method of making that marble, which is very cool. You never claimed the marble made by such a process. And the answer is you don't have to, okay? Because Section 67(1) of the Act makes provision for certain presumptions relating to patents for products produced by a process. And where there is a patent for a process for producing a product, the patent is interpreted as extending to the product if the product is produced by the patented process or apparatus. So Section 67(1) says a claim in respect of the patent for a process for producing any product shall be construed as extending to such product when produced by the process or the apparatus claimed. Okay, so if you've got the marble and you can only make this marble by the patented process, then importing, keeping, making, using, disposing of this marble is an infringement of the patent, because the patent claims a process and the process extends to the marble that you made if it's unique. Okay, and here's the tricky bit. Okay, 67(2), I'll read it to you. If the invention for which a patent is granted is a process for obtaining a new product, a marble, the same product produced by a person other than the proprietor of the patent or their licensee shall, unless the contrary is proved, be deemed in any proceedings to have been obtained by that process. So what you have there is you have a balance of convenience that lies in favor of the patentee. So if you come across that marble and you're suing somebody for having that marble, the guy who's being sued has to prove to the contrary that it wasn't obtained by the process, because the presumption is that it was obtained by that process. Okay, so that's something which is definitely in favor of the patentee. Okay, very interesting, in favor of the patentee. Dean and Dyer says the onus rests on the patentee to show that the alleged infringing product has been made by the patent process. But of course, that's wrong, because it says here, the proprietor of the patent shall, unless the contrary is proved, be deemed in any proceedings to have been obtained by that process. Okay, so a new product shall be deemed to have been obtained by that process, and it's the person who's on the hook for infringement who has the onus to prove the contrary. So that's just an interesting little aspect of patent law. So one of my favorite questions is whether you think the Patent Act as it now stands is pro-patentee or pro-third party. In other words, do you think the Patents Act is biased towards the inventors and the owners of the patents? Or do you think it's biased towards third parties and people who are infringing? And when I ask that question, I would be looking for you to discuss sections such as this, because section 67.2 is clearly in favor of the patentee. Okay, it's given him the presumption. It's saying if you've got that marble and you can't explain it, then I'm just going to assume that it's infringing my patent. That's a huge advantage for the patentee. Okay, so that kind of suggests, well, the Patent Act is maybe a little bit biased towards the patentee. But then last week we spoke about partial claims 1 through 26. Claim 27 is bad, so I've got to go back to begin and amend my claim, delete claim 27, or amend it to the form where it's. And unless I do that, my infringer is going to get away scot-free. Well, that's my reading of Deaton Engineering, which I know you guys have all read in the last 2 weeks. So that seems to be a little bit biased towards the infringer, right? And not very patentee friendly. So it's a very interesting question. Is the Patent Office pro-patentee or pro-infringer? And there are aspects of this all through the Act. And it's little things like this which if you're in an open book exam, this is how it goes. Okay, I'm not gonna ask you to set out the infringing acts in terms of section 45. That's super easy. That's undergraduate stuff. I'm going to be asking you to analyze. I'm going to be asking you questions about cite aspects of the Act which are pro-patentee, cite aspects of the Act which are pro-third party. Tell me why the Act doesn't make provision for artificial intelligence to be an inventor. Things like that, whereby you've got to have a good working knowledge of the Act, get around, jump from section to section, cite case law, etc., etc. I want you to demonstrate an understanding of the Act. There's going to be no rote learning. There's going to be no just, vomiting it up on the page, giving me back, the grounds for revocation or anything like that. No, it doesn't work like that. This is postgrad. And you need to demonstrate a fundamental understanding of the Act. And it's little things like this: presumptions in relation to new substances, partially invalid claims, conduct of the patentee. These are the dark corners of the Act that we're going to be exploring in the Act. And you'll see from my past papers, which I still have to post, don't worry, I will, just how I approach these things and what kind of questions you're going to be asked to answer on the day. Incidentally, yesterday I got an email just confirming the exam timetable. I'm sure you will have got it as well, but I will send it out to you. It's Wednesday, the 15th of June, 8:30 to 1:30. What's that? That's 5 hours. Yeah, open book in Auckland Park campus. I will be there. I'll be there invigilating on the day. So if you have any questions, you can ask. And I'll have some tissues with me so that if you start crying, I can offer some consolation there as well. But I will be there on the day and we will spend those 5 hours together. 15th of June, 8:30 in the morning. Looking forward to it. Okay, moving on. Marketing approval, section 69A1 of the Act. We've spoken about that. So we're not going to really go on anything more about that. That's the BOLA provisions. Just to confirm that it is not permissible for a generic manufacturer to stockpile a product prior to the expiry date of the relevant patent with a view to commercial sales immediately after the patent expires in terms of 69.1. So that's a very important proviso. Okay. All right. So we have now established that this third party, the alleged infringer, has conducted one of these acts. He's made it, he's used it, he's exercised it, he's disposed of, he's offered to dispose of, or he's imported the patented invention. Now we turn our attention to construction of the claims. And so once it has been established that an act of infringement has in fact been committed, the determination of infringement commences. The claims define the scope of the monopoly, and obviously, so that is what we focus our attention on. Now, so now we look closely at the wording of the claims, and there are basically two ways of looking at it. Our courts have held that there's only one type of infringement, but in fact there are in fact two. There's literal infringement, which is easy, and then you've got something which is slightly more slippery, which is called the doctrine of purposive construction, or sort of the intention of the drafter. Okay, so let's start with the easy one first, literal infringement. Okay, this is where you look at the wording of the claim and you say, look, it's either there or it's not. So if we go back to my favorite example, a bicycle which is painted green. Okay, so you break it up into integers. It's a bicycle, it's painted, and it's green. The color it is painted, it is green. So you've got those three integers. Now, that's a super easy claim, a bicycle which is painted green. Great. You must understand, in practice, you have claims which are pages long, and the integers are just horrendous. So, like if you're claiming a chemical compound, you say you've got a benzene ring, and then over here you've got, it can be a hydrogen or a hydroxyl or an ammonia or a this or a that, and then down here you've got something else, and the combinations and permutations go into the hundreds, the thousands on occasion. Okay, so claim construction can be your absolute worst nightmare, but for us it's going to be super simple. We're talking about a bicycle which is painted green. Great stuff. Okay, so first thing, a bicycle. What is a bicycle? Well, it's got two wheels. So if the infringing article has only one wheel, in other words, it's a unicycle, it doesn't infringe the claim, because my claim says a bicycle, and bicycles have two wheels. If you've only got one wheel, you don't satisfy your integer, you've escaped. Thank you and goodbye. What about a tricycle? A tricycle has got three wheels, okay? A bicycle has got two. So I would suggest that if you say bicycle, then if the infringing article is a tricycle, you don't infringe, because bicycle has two wheels. If you were to turn that claim around and say, instead of saying bicycle, you say a vehicle having at least two wheels, then tricycle falls within it, because bicycle is more limiting than the phrase a vehicle having at least two wheels, because a vehicle having at least two wheels includes bicycles, two wheels, tricycles, three wheels, and quad bikes, okay, 4 wheels, and 5, and 6, and 8, and 16, because it's got at least two. So do you see how important it is when you're drafting your claims is to apply your mind? Because the term bicycle is very limiting. Bicycle means two wheels and two wheels only. One wheel, you escape. 3 wheels, 4 wheels, 6 wheels, you escape. So, it's really important about the wording you use. So that's literal, okay? So you say, the first thing you do is you look at the infringing article. How many wheels does it have? 2. Okay, cool. It's a bicycle. It satisfies that. Does a bicycle have to have a saddle? Well, I would hope it has a saddle, but whether it's got a saddle or not having a saddle, it's probably still a bicycle. Does it have to have a bell? Certainly not. Okay. Does it have to have brakes? Again, preferable, but not necessary. So, you know, we can talk about what constitutes a bicycle and what's not a bicycle, but basically a bicycle basically means, you know, an apparatus having two wheels. So if you've got two wheels, boom, you're in the claim. And, you know, you can argue about, oh, it doesn't have a saddle or it doesn't have a bell, it's not a bicycle. You know, you're barking up the wrong tree there, but you can have a go. But you can kind of see how these court cases turn out. There's a lot of gray areas in here. But anyway, literal infringement, two wheels, bicycle, let's go. Is it painted? Okay, it's either painted or it's not. Has paint been applied to it? Yes. Does paint have to be applied across the whole thing? No. Just an area has been painted. So not the whole bicycle, just an area will be sufficient. And then green. What's green? Okay. And again, what is green? And so again, we come to that Pantone reference thing whereby if you just say green, you know, it's really difficult. If you leaf green, I'm trying to think, I don't have anything. This box of tissues, okay. I don't think anybody's going to argue that that's green. But like, what about the little center part of the daisy? Okay, most people would say that that's yellow, but you know, is it part of being green? So you know, you really must be precise with your what constitutes green and what doesn't constitute green, and that's why you come to Koflex versus Schlumberger, and these are the guys who basically set out the 10 rules for literal infringement, and it's, you know, it's pretty easy, okay. And the 10 rules are set out on page 276. I'll just go through them quickly. It's to ascertain not what the inventor or patentee might have had in mind, but what he actually said. Okay, so I'm not going to sit there thinking, oh, he said bicycle, but he might have meant, you know, including tricycles, etc., etc. If you don't say tricycle in terms of literal infringement, you don't get a tricycle. Okay, you've got to say what you mean. So what his intention was, as conveyed by the specification, properly constructed. Since he is presumed to have intended what his language meant. If he meant to include tricycle, he should have flippin' well said it. Okay, fine. To certain the meaning of the words must be read grammatically and in their ordinary sense. Technical words of the art or science involved in the invention must be given their ordinary meaning, as they are ordinarily understood in a particular art or science. Okay, fair enough. So don't be giving it some weird meaning that you found in the middle of nowhere in some Norwegian dictionary or whatever. Just give it its ordinary dictionary meaning, unless the guy has said in the specification, actually, black means white, green means whatever, you know. I can do that in the spec. I can give a particular meaning to a word, but if I don't do that, then the word is just given its ordinary dictionary meaning. I can get experts in to say, you know, when John talks about a photo multiplier, he means this, you know, because John didn't give a definition. So I'm an expert in the field of photo multipliers, and this is what a photo multiplier is. So from that point of view, evidence can be given by experts. But if you read number 10, the evidence of experts' opinions in the meaning of the specification is inadmissible and must be disregarded. So when he says, you know, an expert can say, this is a photo multiplier. I'm an expert in my field. This is what I mean by what a photo multiplier is. But then I don't get to go to the next level as an expert by saying, and so I think John meant to say whatever. Okay. So experts must be ring-fenced. They must just apply their expert meaning to particular phrases or the meaning of words used. They mustn't then come in and say, well, I think John meant this or whatever, because that's not how it works. Not in literal infringement anyway. Okay. Extrinsic evidence is not admissible to construe the specification, such evidence would not necessarily be available to enable interested members of the public to understand. So, you know, again, I've touched on this before. That specification, you must be able to pick it up as a person skilled in the art and put it into practice. If you suddenly need this textbook and that scientific paper and then, you know, apply that reading, it's not utile, okay? It's ground for revocation. You can't start introducing, you know, third-party references, etc., to understand, to get this patent to work. It's got to be self-sufficient on the face of it. It's got to be self-supporting. So that's an important aspect of it. Okay. This is my favorite one, the next one. Specification must be read as a whole. If on such reading it appears that a word or an expression is not used in its ordinary sense, but with a special connotation, it must be given that meaning. Okay, so what this basically means is, say your invention relates to trucks and towing things, and you use the word trailer. In that context, when the specification is read as a whole, you know the meaning of the word trailer relates to a sort of wheeled vehicle which is dragged behind a main vehicle. Okay, that's a trailer. So you can't suddenly start saying, oh no, trailer means an advert for a movie, you know, because, you know, trailers for movies are completely different as trailers for trucks. And if the whole invention is talking about trucks and, you know, towing and vehicles for towing, etc., and you talk about a trailer, you've got to give it its meaning in that context. You can't be difficult and say, oh no, he really means a trailer for a movie, because a movie has got nothing to do with that. So you've got to contextualize the meaning of words, particularly when a word can have a different meaning. Okay, so and there's lots of examples of that. Like, you know, that's why you should be quite careful about using acronyms. So, for example, an APC. Hey, Sally, can you just mute? We're picking up some background noise from you there, Sally. Thanks.
Don't send a message, it doesn't do anything. That's the outcome of lipstick on, which you should have done that.
Sally, can you just mute?
I see you when drum say about a photo shoot.
There we go. I didn't realize I could do that myself, but now I do. Okay. Right. What we're talking about? Oh yeah. So we should guard against using acronyms like the acronym APC. If you work for Unilever or Johnson & Johnson and you talk about an APC, you're talking about an all-purpose cleaner, right? Like Jik or Mr. Min or something like that. So when you say APC, it's an all-purpose cleaner. But if you work for the Ministry of Defense and you talk about an APC, you're actually talking about an armored personnel carrier. So you must be careful that the phrasing and the terminology that you use must be clear from the context, and it must be clear that you refer to one thing and not the other. So just remember that going forward. Okay. Yeah, so again, 6. If a word or expression is susceptible of some flexibility in its ordinary connotation, it should be interpreted so as to conform with and not be inconsistent with the rest of the specification, which is kind of just what I've been talking about now. Ordinarily, the meaning of the claims, as ascertained from their own language, must prevail over the rest of the specification. If the meaning of a claim so ascertained is clear and unambiguous, it is decisive, and it cannot be restricted or extended by anything else stated in the body or title of the specification. Bearing in mind that the specification is your opportunity to say what you like, but a claim stands or falls by the language used in the claim. So you'd be hard-pressed if a claim is clear on the face of it to say, oh, no, it's actually broader because, you know, here in the spec it says this. If the claim is clear, the claim is clear in the story. But if it appears from a reading of the specification as a whole that certain words or expressions in the claims are affected by what is said in the body of the spec, the language of the claims must be construed accordingly. So you can see how he's saying, oh, the claim is a claim, but if you say in the specification black actually means white, then you've got to import that meaning into the claim. So, you know, you've really got to engage your brain when you construe claims, because, as I say, a drafter is completely free to build his own dictionary. He's completely free to give meanings, particular meanings to words. And if he does that in the body of the specification, then that has to be taken into consideration when construing the claims. And finally, if a claim is ambiguous, the body and the title of the spec can be invoked to ascertain whether at least a reasonably certain meaning can be given to the claim. So that's where you know, you're not clear exactly what the claim says, then you go back to the spec to say, oh, when he says this, he actually means this. And that's why it's so important that when you draft a specification, that when you have your claims, each of the claims is built, has got basis in the spec, so that you can find that claim, the basis for that claim in the spec, and then read around it to contextualize that claim and see what's going on there. So that's a very important part of claim construction, is reading it in context with the rest of the specification. So that's it. That's literal infringement. Okay, it's pretty easy on the face of it, but it's pretty easy on the face of it, but it's quite unforgiving on the drafter, right? Because, you know, if he meant to say any vehicle having at least 2 wheels, but he said bicycle instead, and in so doing excludes tricycles, quad bikes, etc., you know, it's quite tough on the drafter. So it's very unforgiving. So there are circumstances in which the courts may still find that a product or a process infringes the claim. And what they're basically doing here is they are being more forgiving in their approach to the patent drafter. They are trying to sort of give him a little bit of wriggle room, and they're trying to focus on what he actually really intended. And there's the case on this, which you have to read. It's like, you totally have to read this case. Is Frankenhirsch versus Rody versus Wienerberger. It's a 1960 case and relates to watch straps. And in particular, do you remember those elasticated ones? You don't really see them anymore, but, you know, used to just, you know, they were biased to a closed position, and you just slip them over your wrist and away you go. So there was a patent there, and this is what the judge said in Rody versus Weinberger. Assume that a claim has got integers A, B, C, and D, okay, and that A, B, and C are essential, but that D, even though mentioned in the claim, is in fact not an essential integer. If the alleged infringer omits A, B, or C in his apparatus, they're essential. He doesn't infringe the claim. But if he leaves out D, so far as D is concerned, it does not matter what he does. If he has taken A, B, and C, he has infringed, whether or not he's got D. Whether he leaves D out entirely or keeps it or substitutes a mechanical equivalent for it. So, okay. So now all of a sudden we're like, what the hell? You know, under literal infringement, he said A, B, C, and D. And even though D is not essential to the invention, if I omit D, I don't infringe. But now under purposive construction, the doctrine of the pith and the marrow, as in, you know, we focusing in on the essentials of the invention, now that seems to prevail. So the next case that they spoke about it was Catnick components, and purposive construction of a claim requires the claim to be divided into its relative integers, and thereafter a determination is made as to which of these integers are essential. And the doctrine of purposive construction was stated by Catnick, where he talks about, you know, sort of looking at what the intention of the drafter was. In order to determine what are and what are not essential integers of the claim, the specification has to be read and interpreted with the understanding of persons with practical knowledge and experience of the kind of work in which the invention was intended to be used, and in light of what was generally known by such persons at the priority date. Okay. So after you do that, then the court will figure out what's essential, what's not essential, and he'll disregard what's not essential. So this is just a massive, massive gray area. Okay. And what it does is it's just giving a little bit of leeway for poor drafting of the specification. So I'll give you an example. Okay, so under literal infringement, if you say a doorway and the lintel of the doorway is horizontal and 90 degrees to the sides of the door, and now you build a door where it's actually 85 degrees. Under literal infringement, you wouldn't infringe, but under pith and marrow, the court would kind of say, the most important thing is to have that lintel, which runs sort of along the top of the door. And whether the door itself is at 90 degrees or 85 degrees or 80 degrees, it's really not here nor there. The main thrust of the invention is to have that lintel supporting the top. So if your door is not exactly 90 degrees and it's 85, it's still, the invention still works. And that's what pith and marrow is about. It's a lot more forgiving towards the drafter, and it tries to focus on what the actual invention is and to take it from there. So as drafters, as patent attorneys, we are very aware that we never want to be in a situation where a court is trying to give us the benefit of the doubt or whatever. So we will always be very careful in how we draft. But, you know, pith and marrow exists to give poor drafting a bit of a get out of jail free card by looking at what essentially the invention is and taking it from there. So yeah, from our point of view, a little bit tricky, but all you have to understand is that there are two ways that you can interpret a claim. You can do literal infringement, or you can do purposive construction. And literal infringement is like, as I say, you give words ordinary meaning, you look to the spec. If there's a definition in the spec, you use that and you take it from there. And then purposive construction is you say, well, you know, I'm looking at that integer, I don't think it's necessary because the invention is this, and that seems a bit extraneous to the invention. So from that point of view, I don't think it's necessary. So I'm going to give the patentee a little bit more leeway. So there's nothing in the Acts about how you construe a claim. So this is all derived from case law. And that's why Roddy versus Weinberger Catning components are so important in understanding literal versus purposive construction. So it's a little bit difficult that you've got to derive it, but you've just got to understand that there are different ways of skinning this cat and looking at it. And that's kind of how you do it, literal or purposive construction. So there we have it. Okay. We've dealt with the role of expert evidence, and so now we're on the third part of the infringement determination, which is to say, okay, we've got this act. Just one sec.
Where's the blue Audi?
Mom's taking. Just doing my lecture.
Okay, because the silver car's not there. Mom took the silver car.
Oh, I think it's in the garage. Sorry about that. Okay. So we've determined that it's one of the 6 acts. He's made the invention, he's used it, he's exercised it, he's disposed of it, he's offered to dispose of it, or he's imported it. And we've determined the ambit of the claim, which is to say that act that he did falls within the claim, okay? He's made a bicycle, it's got 2 wheels, which is painted green, and we accept what is green, and that at least a portion of it has been painted green, and it's got 2 wheels. And he made these things, and he disposed of them, he sold them. Okay, so we've got 2 out of 3. Now, what we've got to talk about is, does he have a defense? Okay, so this is the bit where the alleged infringer gets to talk, to say, you know, you've heard his story, now it's time to hear mine. And this is why I'm going to advance a statement for the defense, as it were. So the defenses to infringement are not listed in the Act. So that means that unlike the grounds for revocation or whatever, they're not limited. Okay, you can invent anything as a defense. But the most common ones are, first of all, man, I didn't infringe. My bicycle's not green. And here's my arguments as to why it's not green. I don't satisfy an essential integer. It's not infringement. End of story. The patent is invalid for one of the many reasons that we discussed last week for revocation. It's not new. It's not novel. It wasn't applied for in the right name. It was applied for in fraud of rights. It relates to a method of treatment or something which is not an invention per se. All of the dozens of reasons why a patent is not patentable and subject to revocation, that can be, you know, a defense. And so what often happens is that the most usual defense is that claims are invalid, or it's not patentable per se, and you counterclaim for revocation of the patent. So when you get sued for infringement, you say, actually, that patent is not valid, and boom, you just turn it straight on its head, and you know, back at you, patent is invalid. Application for revocation, counterclaim for revocation. Okay, and that's because of invalidity of the patent. Okay, Another defense, which is quite common, is exhaustion of rights, and we will explore these in greater detail. But that's basically where I've bought it from the patentee. He's got his money. Now he wants it again. He doesn't get to have a second bite of the cherry. It's bought and paid for. I can do with it as I please. But as you might imagine, there's a little bit more to exhaustion of rights than you might think, because it's one thing buying it from the patentee, but now I'm buying it from his agent, or now I'm buying it from his licensee, or now I'm buying it in Dubai from the patentee in Dubai, but I'm importing it into South Africa. I didn't buy it from the patentee in South Africa, so grey imports. Is that exhaustion of rights or not? Fantastic case about that. Awesome exam question, just saying, and we'll talk about that in a moment. So that's exhaustion of rights. Speaking of exam questions, Gillette defense. Man, I love this one. Okay, I'll chat about Gillette defense. Being caught on the horns of a dilemma. Leave and license, acquiescence, election waiver, and estoppel. Okay, so, and I'll get to those. So let's just talk about the Gillette defense. Okay, so this relates to an old case, and it's from Gillette Safety Razor Company, which we've spoken about earlier. And basically what it is, it's related to safety razors, okay, when they were quite new on the market, which is, so not the old cutthroat ones, but suddenly ones where you had a cap on the blade, just a little bit of the blade was exposed. So it was much more difficult to cut yourself, and they were very popular. And there were a lot of patents on them at the time. And that's, of course, how Gillette made their money. They were big razor manufacturers back in the day. And what basically happened was they sued somebody else, I can't remember who it was, for Anglo-American Trading Company, not the Anglo-American we love today, another Anglo-American. And they said that they infringed, Gillette said it infringed our patent on the safety razor. And so what Anglo-American did was, at the time, that Anglo, was they said, well, actually, this is our razor, and this is what you say is infringing. Is that right? So this is a thing we make and sell, and it's infringing, right? That's what you say. And Gillette were like, yes. And they said, and so Anglo said, well, actually, this is exactly what existed before the date of your patent, okay? So we were making and selling this before you applied for your patent. So now you're on the horns of a dilemma, because if you say that this is exactly what's in your patent, then your patent is invalid, because this existed before the date of your patent. It anticipates your patent. Your patent is bad for lack of novelty. So if you say this falls within the patent, it must anticipate the patent. The patent is bad. The only way your patent is going to get to survive is if you admit that our razor that we're making is in fact different from what's in your patent. And if it's different from what's in your patent survives, because this is different, so it didn't anticipate what's in your patent. But it's also what we're making and selling, so we don't infringe by definition. Because if we infringe, your patent is bad, because this razor, which we're making and selling, predates your patent. So Gillette were like, oh my God, he's right. If we incorporate our claims, interpret our claims to include what they do, he's able to prove that that existed before the date of our patent. We therefore invalidate our patent. But if we interpret our patent, construe our patent so narrowly that that razor falls outside of it, we survive because we're focusing on something which didn't exist at the time of the patent, but he gets away with infringement. So either way, Anglo-American walk free. And that's called the Gillette defense. And it's because it's an interesting defense in that it puts the patentee on the horns of a dilemma. If a patentee seeks a broad interpretation of the claims, they may be found to be invalid for lack of novelty. But if the patentee seeks a narrow interpretation, the alleged infringer will escape a finding of infringement. Pretty clever, huh? So it's like catch-22 kind of thing. It's called the Gillette defense. I strongly encourage you to read that case. It's an interesting case. Let me know if you can't find it. I can send you a copy, or I might put a copy of Gillette up actually onto Blackboard so you can all read it. It's a great exam question because it talks about anticipation, lack of novelty, claim construction, avoiding infringement, all of these things, all boom, banged into one. The question has arisen, could you claim the Gillette defense per se in South African law, which then just brings all of this together as one turnkey defense? And, I think probably not. I think it's a bit of an odd question, because you're going to argue either revocation for novelty, or you're going to argue escaping claim infringement per se. Anyway, but just when you package it together, it's the Gillette defense. But it's a cool defense, and it works well, and there's fantastic case law on it. So, I would really, I'd look at that, because it's been an exam question before, because it just encompasses so much, right? And that goes again to what I was saying about how I don't want a slavish, just, a rendition of what's in the Act. I want some interpretation. And so a discussion of Gillette Razor is a good one from that point of view. So that's the Gillette defense. Let's talk about leave and license now. The defense is usually based on the alleged grant of a license under the patent from the patentee to the infringer, and it doesn't have to be express. It doesn't have to be in writing. It can be implied. And so what you would be looking for there is the conduct of the patentee. So if the alleged infringer could prove, listen, man, I've been doing this for years. This guy's known about it for years, and he's got a problem with it after all these years. He's never had a problem with it before. He's never said anything about it before. You could argue that there's a tacit license in place. Would I like to go that route? Maybe, maybe not, because it's well known that infringers can take their time as to when they want to institute proceeding for infringement. Patentees, they can even sue after a patent has lapsed, after it's 20 years, if they want to. They don't have to bring an action as soon as the acts of infringement come to their attention. So it's a bit of a tricky one. But if the conduct of the patentee is such that you can infer a tacit license, then that's something that could be argued. Incidentally, what's the difference between infer and imply? Okay, I infer something if I take it from your behavior that you are okay with it. I am inferring that I have a license. It's not anything, it's just what I take from you. Okay, so I infer, I take something from you. You, as the patentee, imply through your actions that there is a license. So it's something that you do rather than the infringer. So if you look up Google and you say infer versus imply, imply means to suggest or say something in an indirect way, but infer means to suppose or come to a conclusion based on an indirect suggestion. Okay, so infer is something that I take from a situation. Imply is something that I give to a situation. So it's important to use those words correctly when talking about leave and license, because implication is the actions of the patentee, and inferral is the actions of an alleged infringer. I inferred I had a license because the patentee implied that. Okay, so again, just a little bit of semantics, but language is the manner in which we communicate, and in that endeavor, there can be no excuse for laziness. So language is very important, and it is a precise medium, and it should be used precisely. So you should understand the difference between imply and infer. Okay, let's talk about exhaustion of rights. Okay, so again, this is classic intellectual property, classic IP, patent law, because on the surface, it's very simple, but then you just have to scratch a little bit and you realize just how complicated it gets and how quickly it gets complicated. Okay, so the case is Stafford Chemical Company, And it basically goes to, Stauffer had a US office and Stauffer had a South African office. And they were selling product A both in the US and in South Africa. But the product that the South Africans were selling, exactly the same, was like 3 times the price of what you could get it for in the US. So what they did was they got they bought it in America and they imported it into South Africa, and were promptly sued by South Africa to say, "Oi, we've got the monopoly on this product A in South Africa." And these guys were like, "It's exactly the same product. We bought it from you. We bought it from Stauffer, just in the US. How can you say we infringe?" And the judge said, "Well, it all depends on the circumstances and what rights the company in the US had to sell it to you." Okay, so basically, bottom line is, in the defense of exhaustion of rights, the infringer pleads that he acquired the infringing article directly from a patentee, and thus the patentee's rights over the article have been exhausted. And the court said, okay, well, look, I'm going to divide. That can happen under 3 circumstances, and we're going to examine each one and see whether, in fact, the rights have been exhausted or not. So, where the patentee himself sells or disposes of the patented article, that article is free from all restraints, and the patentee's rights have been exhausted. Easy. When you buy it from the patentee himself, sorted. Where the patented article is disposed of by the patentee's assignee or his agent, acting within the scope of his authority, also easy peasy, rights exhausted, okay? Because he was allowed to sell it, he sold it in terms of the license, it's all good, okay? Third one, more complicated. Where the sale of the patented article by a licensee or a patentee, the matter must depend on the extent of the authority conferred on the licensee by the licensor under the license of the agreement. So basically what Stauffer said was, the Americans had a license to sell this chemical in America, but the terms of this license said that they must only sell it on condition that it's not exported from America. So that was the terms on which the infringer bought it. I mean, whether he knew that or not, I don't know, but turns out that he bought it under conditions that it could only be used in America. So when he exported it into South Africa, it was in fact an act of infringement, even though he bought it from the same sort of company. But because of cross-company licenses, sales in America were only for use in America, couldn't be exported, couldn't be imported into other territories. And so that's why the third rule, which was explored by the judge, which says that where the sale of the patented article is by a licensee, the matter must depend on the extent of the authority conferred upon the licensee by the licensor under the license or the agreement. Okay, easy peasy. So that's exhaustion of rights. Again, so it starts off super easy. If you buy it from the patentee, rights exhausted. If you buy it from his assignee, the person he's bought it from, or his agent, probably good. If you buy it from a licensee, now you must look at the terms of the license. So it's, you've got that added layer of complexity there. Okay. Next offense, acquiescence, election, waiver, and estoppel. So this is pretty similar to leave and license. For this defense, the onus is on the infringer, and he must show that the patentee, with full knowledge of his rights, decided to abandon them, the rights, that is, whether expressly or by conduct plainly inconsistent with an intention to enforce them. So it's it's slightly different from a tacit license. You've got to believe that as an infringer, that the patentee had no interest in the patent. He was going to allow it to lapse. He wasn't paying the renewal fee. He was not interested. He did not give a monkeys about it. That's what you've got to prove. Super difficult. So again, this is not a very common one, because can you imagine senior counsel arguing the facts of how you drew the conclusion that he had decided to abandon the patent? Not somewhere I'd want to go. You guys will know what estoppel means, eh? So estoppel means that where the patentee has said one thing, he said, I will never sue company A for infringing my patent, ever. And then 3 years later, he sues company A for infringing his patent. Company A will turn around and say, you said that all those years ago. Under oath, you had an undertaking. You are now stopped from suing me because of what he had done previously. So from that point of view, that's something that you can rely on, estoppel. Again, very uncommon. I mean, as a patentee, are you ever really going to say, I will never sue company A? No, nobody's going to do that. So it doesn't come to pass very often as a way of doing it. So that's something to bear in mind. Okay. Ignorance, not a defense. Okay. So this is quite important. You can't say, well, I didn't know. Ignorance of the existence of a patent is not a defense. Accordingly, a defendant cannot claim that he was not aware of the existence of the patent, and by so doing, avoid the consequences of infringement. And that's because all patents are, in fact, open to public inspection, right? So you are deemed to know about them because anybody can go down to the patent office and look up the patent and see. It's deemed to be public knowledge. The fact that you, in fact, had never done that is neither here nor there. The most important thing is that you could have done that. And so you are deemed to have done that in a sense. So ignorance that you are infringing somebody else's patent is no defense. That's important. Invalidity of a single claim, section 69. We discussed that last week. McKelvey versus Deaton Engineering. One bad apple rots the barrel. Yes. So you will have read all of those cases, so you can see that's pretty pro infringer. And so puts a lot on the desk of the patentee. So that's important to bear in mind. Okay. One of the last things I want to talk about is contributory infringement. Okay, so contributory infringement is tricky because now this is not me who's infringing it, but through my actions, I am putting somebody in a position to infringe the patent. And in so doing, I have the ability to, to be sued for infringement. So it comes from the fact that infringement of a patent is actual delictual. And we've all done delict in our undergrads, haven't we? I'm sure it brings back terrible memories. And the 5 requirements for delict must be present in order for a patentee to prove infringement. These are an act, wrongfulness, fault, harm, and causation. Okay. If you can prove all of those, even though you didn't actually do the act of infringement, then you can be on the hook for contributory infringement. Now, there are 2 cases which are really critical. The one is carbolic smoke ball, which I don't think I mentioned actually. But then the other one, which is the big one, which I do want you to read for sure, is dynamic fluid control. And basically what dynamic fluid control is all about is the patent in question claimed means for venting air from a pipeline using a valve with the following characteristics. Okay. So the defendant made and sold the valves that had these things, but the valves weren't actually the subject of the patent. The subject of the patent was a method of venting air from a pipeline by using these valves. But when you made and sold these valves with instructions on how to vent air from a pipeline, that is contributory infringement because you were putting the person who bought the valve and the instructions in a position to infringe the patent. So the use of the valves in the pipeline resulted in an act of contributory infringement, as it was said to be inducing, aiding, and or abetting the purchaser of the valves to infringe the patent. Okay, so that's what contributory infringement is about, is when you put somebody in possession of everything they need to infringe the patent. Whether they do or not are neither here nor there. And you yourself are not infringing the patent because you are not venting air from a pipeline, but you're providing the valves, you're providing instructions, and you're saying, go to somebody else, go ahead and do it. You do it, it's fine. That person definitely would be infringing the patent, but you would be a contributory infringer because you put them in possession of everything they need to infringe the patent, okay? And that satisfies the 5 acts of delict for contributory infringement. So it works. So just because you're not doing it, the fact that you are sort of cozying up and causing somebody else to do it, that is in fact can be contribute to infringement, and you can be on the hook for infringement on that basis. So it's important you understand that the acts of procuring, inducing, aiding, and abetting may in fact constitute acts of contributory infringement, and any person involved in these acts could be held to have infringed the patent. Okay. The intent of the alleged contributor infringer is important, and so again, now we have to start leading evidence as to fact, etc., etc. So it could be quite tricky and expensive to do that. But the fact of the matter is that there is this case. The concepts are clearly set out. I mean, we're good to go. We're ready to go. So it's important to understand that. Okay, that's it. So those are your defenses that you might put together. You know, I don't infringe the patent. The patent is invalid. Your rights are exhausted because I bought it from the patentee or his agent. The Gillette defense about the safety razors, leave and license or acquiescence, and estoppel. So, you know, if those don't fly and you're found guilty of infringement, what happens to you? Okay. So what will you have to do? You'll have to have done one of those acts. You'll have to have made, used, exercised, disposed of, offered, disposed of, imported the claimed invention. Your act will have had to have fallen within the claims as construed, either literally or using the doctrine of purposive construction. And the third aspect is that any of your defenses, advanced, revocation, invalidity, leave and license, exhaustion of rights, will have failed. Okay, you are now on the hook for infringement. What happens to you? Okay. A successful plaintiff in an action for infringement is entitled to the following relief. Okay, and it's section 65 of the Patents Act. That is an interdict. Okay, to stop you from interdicting the patent. Okay, so an interdict, as we well know, is an order of the court ordering you to stop doing something. Okay, it's also called an injunction in many other jurisdictions, an interdict or injunction. So whatever you have to do, all the acts, all the making, using of the patented invention now must cease overnight. Boom, interdict, stop from what you're doing. Okay, an order for delivery up of any infringing product or article. And so all your stock, everything that you're busy making, everything in your stock room, everything that's on the shelf, everything that's on the ship from China coming over gets cleared and gets handed over to the successful patentee. Okay, so you have no revenue stream because you're stopped from making and selling these things, and all of the money tied up in your existing stock now gets handed over to the successful patentee. Okay, and what can he do with it? He can do with it whatever he pleases. If they're good enough, he can even rebrand them, resticker them, and sell them as his own. Okay, he can destroy them. He can have you paid to have them destroyed. So yeah, tricky, you know, expensive. Finally, damages. Now, damages are going to be one of two things. They're either going to be lost profit or reasonable royalty. Okay, and so now normally what happens is there's a big inquiry as to what constitutes lost profit, and then, you know, the patentee has to open his books to say, you know, well, I was making these widgets and they cost me 10 Rand, but I was selling them for 100 Rand, so I made 90 Rand, but then I have to pay for my factory. And so it's a big, you know, sort of accounting exercise, which most patentees are not keen on. You know, they don't want to open their books to public scrutiny. They don't want teams of accountants saying, oh, you know, these are your costs, these are your overheads, this is how much profit you make, etc., etc. So by far the most popular one is to say, oh, look, you know, if I were to license that guy, I would have charged him 10 Rand a widget. So in terms of a royalty, a reasonable royalty. And then the court says, oh, okay, that sounds reasonable, arm's length, etc., etc. He made 1,000 of these things. He made and sold 1,000 of these things at 10 Rand each. That's 10,000 Rand damages in form of a reasonable royalty. And that's by far the most popular thing. So your damages are either going to be lost profits, not popular, because that means opening your books for public scrutiny, which almost all companies will not accept. And then you can just say, well, reasonable royalty, but it's squabbling about what constitutes a reasonable royalty, applied to how many articles were made and sold, end of story. Okay. And then, of course, the last one, and the most important one, is costs of the suit, which is to say, now these are tax costs. So I'm not going to get everything that I paid my patent attorney. I'm not going to get everything that I paid senior counsel, but I'll get half of it, maybe 60% on a tax cost basis. Very, very tricky, very tricky. Okay. So you think about it. You are an infringer. You've got a product line, you make and sell these things, and then suddenly you lose patent infringement. Your business comes to a grinding halt overnight, okay? And more often than not, it'll drive you to the wall in the sense that you will probably go under because you lose your revenue stream. You lose all the money that you've got locked up in stock, okay? Because you've got to deliver up all your products that you've made, you've got in storage, got on the are currently under delivery, on shelf, etc., etc. All of that money, all the money that's locked up in there, gone. Then all the profits that you would have made on the ones that you sold, you now have to hand over in form of a reasonable royalty or other damages as may be calculated. Then you've got to pay for your senior counsel and 50-60% of the winning party's senior counsel. So you are just financially devastated, you know. And so losing a patent infringement battle can seriously damage your wealth. Big guys can often come back from it, but if you're a small to medium enterprise, to lose patent infringement, you'll almost always go under because it's just so expensive. Yeah. So mostly patent infringement is avoided. They settle, they take a license, etc., etc. But you know, the fact that we've got quite as much case law as we have on this goes to show that, you know, a lot of people take this seriously, but for the most part, it's usually just big boys fighting each other. Little guys settle or take a license because, you know, the risk of losing it is just so devastating to a business. And you should understand, I mean, that makes a lot of sense because, you know, the whole idea about patent law is to incentivize innovation. So you can't let stealing innovation, you can't let them get away with it. The consequences have to be severe in order for people to take this whole framework seriously. So it's right that patent infringement is seriously viewed. It's right that losing patent infringement has devastating consequences for you. You need to really think twice before you infringe any patent. So again, that goes to sort of first principles. And again, if you look at just what a successful plaintiff in an action for patent infringement is able to, you know, the relief he's entitled to, I think it's pretty patentee, you know. I mean, he really, when he wins convincingly, he really wins convincingly. He's not out of pocket that much. He can sometimes even turn a profit. So, you know, it's definitely pro-patentee, the whole infringement thing. So that's another one to throw into the basket of whether something is, that the act is pro-patentee or pro-third party. Just something to bear in mind. Okay, the procedure, it begins in the Court of the Commission of Patents. It's a High Court procedure, and they are brought by way of action proceedings in terms of the Uniform Rules of Court. So I just want to go to Section 65, the Act, proceedings for infringement. Should have a look at the regs. In the case of proceedings initiated by a notice of way of motion, a party resident or incorporated outside the Republic, you know, it talks about proceedings, how they serve, time limits, tariffs, etc., etc. Not really terribly important, but important to understand that it's a High Court action, and it might begin in the Court of the Commission of Patents, but that in itself is a High Court, and then, you know, you go from there to full bench or SCA, and quite possibly from there to the Apex Court, the Constitutional Court. There haven't been too many patent cases there, but it's something just to bear in mind. Okay. So that was infringement, which is generally quite simple. But then when you start talking about the Gillette defense, when you start talking about contributory infringement, you know, when you start talking about purposive construction, it gets quite tricky. So I really want you guys, again, as always, these lectures are quite sort of rudimentary. They just walk you through the basics. But then I really want you to sort of consider it, ruminate on these things, and take it from there. So that's what I want you to do. Now, if you look at lecture 4, infringement, 23rd April 2022, which is today, it should technically end with procedure, but actually, you know, it's 10 to 11. I just want to spend the last 2 minutes talking about the last 2 bits in the book there, restoration and patents of addition. And then next week, well, the next lecture, we'll then go and talk about assignment, licensing, hypothecation, etc., because that's interesting stuff. And this restoration and patents of addition is just like a little tail, a residual tail on things. So I just want to talk about that quickly today, and then we'll call it quits. Because it's literally a page in Dean and Dyer. Restoration, so as you know, a patent will last for 20 years from its date of filing, and you get your first 3 years free, but after that, you've got to pay annual annuity fees, okay? Annual. And if you don't pay them, then the patent is said to lapse, okay? And if a renewal fee is not paid, the patent will lapse, and that's easy, section 46, okay? Thereafter, if you've got a 6-month grace period in which you can go, I should have paid, and then you run and you pay a little bit extra, and it's like nothing happened, okay? It's just like, yeah, don't do it again kind of thing. So you've got a 6-month grace period in which you can sort of restore a lapsed patent. By the way, again, just to talk about the importance of accuracy of language, the difference between lapse and expire. Patent expires at the end of its 20-year period. So if you've paid all of the annuities, and then you let it go, and then it dies after 25 years, it expires. But if you don't pay an annuity along the way, it is said to lapse. And a lapsed patent is, under certain criteria, subject to restoration. An expired patent cannot be restored because it's lived its life and it is expired. Okay, so your patent has lapsed. You forgot to pay the renewal fee, you know, for the 5th year, the 7th year, the 17th year, whatever. 6-month grace period. If you don't do it, then it is said to have lapsed. Then to get it back, ooh, that's a mission. Okay, then you've got to restore it. Okay, so section 47 provides that where a patent has lapsed due to the non-payment of a renewal fee within the prescribed period or within the 6-month grace period, the patentee may apply to the registrar for the restoration of the patent. Restoration of a lapsed patent is only possible if the patentee can show 2 things. 1, it was unintentional, and 2, as soon as he heard about it, there was no undue delay before he brought the application for restoration, okay? And that's, again, it makes a lot of sense. It's got to be, so if you say, no, it's too expensive, I don't want to restore my patent, I'm going to let it lapse. And then a year later, you think, oh, there's somebody infringing it. No, we can't be having that. I want it back. You won't get it restored on that basis because it was always intentional that your patent lapsed, okay? You said it was too expensive at the time. So when your patent attorney writes to you and says, hey, do you want to restore your patent? Do you want to pay the renewal fee? And you write back and say, no, it's my intention to let it go lapsed. Boom. That email, you'll never get it back after that. Okay. So you've got to demonstrate that it was unintentional, which meant to say that you never had any intention of the patent lapsing. That's the first thing. And the second thing is that you've got to show, as soon as it came to your attention that the patent had lapsed, through non-payment of the renewal fee, you jumped up and immediately instructed your patent attorney to make a plan. And that's because restoration of a patent is really important. I mean, you know, people are looking at your patents and then it lapses, and then the 6-month grace period passes and you say, well, hey, this is something I want to do now. So you start piling in, you start importing the product, you start building a factory, you start having distribution networks, etc., etc. You can really go crazy on what you want to do with it. So, you know, you can, you know, you don't want then after you've taken all of that trouble, boom, the patent suddenly restores back again. Look, that can happen under certain circumstances. Again, if these 2 criteria are met, 1, no undue delay, and it was always unintentional, then it might be able to come back. But for the most part, you want some certainty that once a patent has lapsed, it's gone and it's not going to be coming back. So to restore a patent is a big mission, and you have to do these things. And some patent offices are extremely unforgiving in restoring a lapsed patent. South Africa is kind of like, tell me your story. Oh, okay, maybe, yeah, fine. Europe, it's like, nah, you should have had a redundant system. You should have done this. You should have done that. So yeah, it's quite difficult to restore. You're in drama if you allow a patent to lapse and you want to restore it. And most importantly, where if a third party has spent time, money, labor with a view to entering the market with a product, but is suddenly prevented from doing so because this patent, which had previously lapsed, is now suddenly restored, then that person can apply to the patentee to say, you're an idiot. I spent time, money, labor. I want that back. I want to be compensated for it. And the courts will make that order. They'll say to the patentee, yeah, look, you got your patent back. You now have the right to exclude him, but you need to compensate him because he spent money while you were busy restoring that patent. So that's an important thing to bear in mind. Okay. So that's restoration. Okay. Patents of addition, weird little thing in South Africa. You don't really get them elsewhere, but you can have your patent and you can suddenly think, this is an improvement to it. And so you can draft like a little backpack of a patent called a patent of addition, which just sits on the mother patent. It has maybe a few more claims. It's got its own date of priority. You don't pay renewal fees on it, but it only lives as long as the parent patent. So if you do your patent of addition after 10 years, your patent of addition will only have 10 years to go. If the mother patent lapses because you didn't pay the renewal fee, the patent of addition dies with it as well. Patents of addition are not very popular. Normally, if they're novel and inventive, then they should form their own application, which will get their 20 years, and et cetera, et cetera. So patents of addition are for make an addition, an improvement, or a modification of the invention, which wouldn't really stand on its own feet, but it is dependent on the parent invention. Then it works on that basis. So they're very odd. They kind of work, but they're not common in South Africa. The advantages of a patent or addition that the invention claimed does not need to involve an inventive step over the main invention, and that no renewal fees are payable. But the disadvantage is that they last for less than 20 years, being the life of the main patent. Okay, and that's it. That's the end of today's lecture. Next week, now I want to talk to you about that. Next week, I think I said to you that what we're going to do is we're going to have next week, the 30th of April. I can't make the 30th of April. I've been called to Cape Town on a matter, so I'm going to be there that day. So what we're actually going to do is we're going to have it on, I think, the 7th of May. Yeah. So we'll have two then, because we were supposed to have two back-to-back, one this week and then one next week. We're actually going to have a 2-week gap now, which I think works better for you because it now gives you time to work on your assignment more, right? And then we'll have a lecture on the 7th. I just want to tell you on the assignment, I said I wanted it on the morning of Monday the 2nd. I note that, in fact, Monday the 2nd is a holiday. I hadn't picked that up. So you are hereby officially granted a 24-hour extension, and I want that assignment in on the morning of Tuesday, the 3rd of May. Okay? So, Sally, yeah. Got your hand up, Sally?
Yes, about the assignment. I was wondering if you could maybe extend it with a week, if it's possible.
I'm sorry, I can't do that. You guys have had 6 weeks. There are, I'll give you an extra 24 hours, but I need to mark it. I need to get it back to you, and to talk about it. And I need to draft and finalize the papers for the June exams. So it's extremely difficult. It throws everything out to extend the assignment. You guys have had it for quite some time now, and it is still, I think, 10 days or so for you to do. It's only 5,000, so I'm really not inclined to give you an extension. Sorry.
Because I'm a bit, currently I'm a bit overwhelmed with work, so I'm trying to balance assignment and work. So it's a bit of a struggle with me. So that's why I was asking for
Okay.
yeah.
Yeah, as I say, Sally, it's only 5,000 words. It shouldn't be too big. I understand it's a tricky assignment. It does take a little bit of time, but as I say, I have given you 24 hours now until I think what's 24? So it's 7, 8, 9, 10 days still to go. So Sally, I really want you to try, because to push the assignment date out just wreaks havoc with the whole timetable. And I've got to mark it, give it back, talk about it with you guys, everything. So I really want you to try and put it together for the 3rd.
Okay.
Okay. I'm sorry, I know it's difficult for you guys. I'm very appreciative. All of you are in postgraduate study. It's difficult. You're holding down jobs. You're doing it all. But as I say, you've had a long time for this assignment. So I really want you to do the utmost that you can to get it in on the 3rd. As I say, an extra 24 hours is what you've got. Okay. Right. And then also, as I say, no lecture next week. So you can spend some time next weekend working on it as well. And then the long weekend, the Monday as well. So I'm sure that'll be fine. So on that basis, the next lecture will be assignment, licensing, hypothecation, attachment, exchange control, and the IPR Act, all of which are really important. And we'll do that then on the 7th of May, and I'll send an update on that basis, which is after your assignment. So you can forget about that now and just focus on your assignment for the next 10 days. Okay. Just want to say, all right, this lecture will be put up onto Blackboard. I've also got some other documentation about today, about remedies and defenses against infringement and stuff. So keep your eye on Blackboard. It will be augmented with a couple of other articles and things which you may or may not find useful. But otherwise, guys, I think that's everything for today. Still do it 8 in the morning. Yeah, on Tuesday the 3rd. Yeah. We can pull an all-nighter. Remember, it's got to go through Turnitin as well. So I just want to make sure there's no plagiarism there. There's a lot on the internet about this. So there's really a lot you can write about, but I don't want you to cut and paste from the internet resources. Yeah. Who's talking? Tabisa, yeah.
It's me, Prof. Where do we find the Turnitin link?
Haven't you guys used Turnitin before for submission, like last year with your assignments with Vim? Didn't we want them to come in through Turnitin?
I think you have to put the link on Blackboard for us, because it's currently not there. I can't see it anywhere. Yeah.
All right, I will. Okay, if I have to put up a link, then I will, and I'll send it to you. I'll make some inquiries in that regard. Let me just make a note of that.
Okay.
Okay, cool. All right, guys, are we good? No more questions? Sally, your hand is still up. Okay. All right. Great. All right, guys. Listen again. I'm not around this week, but I'm happy to take questions. If you guys are battling with the assignment, if you have questions or anything, drop me a mail. That's how I do things, and you'll get a reply within 24 hours for sure. So don't be hesitate to contact me if you find you've painted yourself into a corner, or you feel you've gone up a blind alley. But I think the assignment is juicy. There's lots of resources out there. Requires you to really have a good look at the Act. Yeah, and I really look forward to hearing from you. Failing which, I will see you again on the 7th of May. We'll probably do it again like this on a Saturday morning on Teams, and keep an eye on Blackboard. This will go up there, and then we'll take it from there. And that's everything for today.
Prof.
Yo, Tabisa.
Last question, is there a bit of wiggle room in the word count for the assignment, or
yes,
we have to stick to 5K?
5K roughly, but like if you're coming in the late 4,000s, I'm not a big word counter. It's all about if you can write clearly and accurately, then you can come in. Between 4, 5, and 5 will be fine. It's not a big deal.
Okay. Thanks, Prof.
Cool. Great stuff. Thanks, guys. Have a wonderful weekend. Let me know if you have any questions. Otherwise, we'll chat soon. Okay. Bye now.